morning. Today, we're going to talk about I-9, E-Verify, ICE, and immigration compliance. So, Eric, thank you for hosting it and having it at HR Simple, and we'll launch into it if that's all right, Eric. Is that good with you?
Yeah, let's just get cooking. Thanks, Julie.
All
Thanks
right.
for coming out.
You bet.
Just go
You
for
bet.
it.
All right. So, we've got a lot to cover and lots of good tools and information in the PowerPoint. So, let's roll. First, we want to thank you for attending. We'll talk for about an hour. We'll have some question and answer. Don't forget you have a chat room that, again, you can send your questions, and I'll try to get to them as we're talking about it or at the end. There may be more questions or assistance people need afterwards, so don't hesitate to call, but hopefully that will work for you. If you want to enter into a question, you'll see that there's a little space for that, and just enter it in there and type it, and we'll follow up. HR Simple is committed to doing webinars and helping educate businesses and HR professionals and managers and everybody else out there dealing with a variety of issues. And HR Simple will email you a recording and the slides from this webinar afterwards. And don't forget, you can always visit youtube.com/HR Simple to watch their webinars. So let's get started. I-9, E-Verify, ICE, and immigration. What does all this mean? What's been happening out there? Well, as you know, people have been waiting a very, very long time for comprehensive immigration reform. For the last decade, we have seen things go up and down and different bills and different focus. Some states have gone anti-immigrant. Some states have been endorsing an immigration reform that's comprehensive, that solves this problem. So there's been a lot of discussion. It's always in the news, and I think now in the new presidential election you hear about it again. So in 2012, though, President Obama made a decision to issue an executive order. And what he did is he said it's called the DACA, or Deferred Action Childhood Arrival. And basically what it says is that individuals who qualify under certain restrictions can apply for DACA and be able to work. And in most states, there was an issue about driver's licenses, so right now they can drive. And so that was something that helped with a lot of kids who had been in this country, graduated from high school, and weren't able to work lawfully because they had no documentation. So that was number one. That's when you saw a lot of people come into your work site and they changed their names or they had ID, and they were very pleased to be able to present it. And that was in 2012. Then President Obama waited for Congress again, and Congress is the only one who can solve comprehensive immigration reform. They waited again to see if they would solve it. When they didn't, President Obama did a second executive order, and that was in November 2014. That was called DACA, so it extended DACA, expanded the DACA program for the kids who were here. They're in high school and around that age. But also DAPA, the parents, so that was the P. So it was to address the parents that have been here longer than the kids. So that got adopted. Then in that case, 24 states sued, and that's been pending to be dealt with, and it's really quite frustrating that it's not resolved yet, but we'll see what happens. It still would be better if Congress would just adopt the program for everybody. But some of it, some of these issues they have is about increasing border security, deporting felons, not families. You'll hear a lot of discussion about things, and it changes the visa programs for high school workers and their spouses. So that's why you have some people coming forward about DACA and DAPA, and this is a little bit about detail about it. It was after the DREAM Act failed. It hasn't been impacted by the court injunction against the expanded DACA and DAPA that's currently in place. So the first executive order in 2012 is still in place today. The 2014 executive order, when all those states sued and said, I want to stop that one with the parents and the kids expanding it, that one is the one that was enjoined. So that one's on hold, and that's pending before the Supreme Court. So keep that in mind. The other thing, it doesn't provide legal status. What it does is defers removal that allows people to be able to work and drive vehicles while they're here. So it's for a 2-year period, and it's renewable if they meet certain eligibility criteria. Some of the eligibility criteria must be for the first DACA, the one that's in place from 2012, is the individual had to come to the U.S. before reaching age 16. They have to prove they continuously resided in the U.S. since June 15, 2007, And by the way, how do you prove that? Well, one of the ways they proved it is video games. Gamers. It's kind of a funny receipt, but they pay for it. If kids were playing it, they can prove they were here. That is a piece of evidence that has been used. So keep that in mind. Because otherwise, how do you prove someone's here since 16? They might have been in school. They might have been doing something else. But what do they pay for? It's not like they have a water bill. They don't always have an employment bill, that kind of thing. Now, if they're under the age of 31 as of June 15, 2012, that also counts. And if they entered the U.S. unlawfully before June 15, 2012, or their immigration status expired before June 15, 2012. So that's the one that's currently there. And they had to be in school, have graduated from high school, or obtained a GED, or honorably discharged veterans. That helps. And they can't be convicted of a felony or misdemeanor. And they had to be present in the U.S. on June 15, 2012. That was the key date for that. And that is the DACA program. If the employee requests employment verification for purposes of DACA, they'll inform HR, the Human Resource Department. The company conducts an investigation because generally DACA eligible individuals not authorized to work until they're approved. So sometimes they may ask for verification, but they won't tell you why. And the companies would have provided it to them, but without knowing, that would be fine. But if they did ask or say, look, I'm not legal yet, I need help and I'm going to qualify for DACA, then you can put them on suspension without pay during that time period. Because they can't work until they actually are authorized by the program. So keep that in mind. HR would provide an employment verification letter that basically says this person worked for this company from this date and time, that kind of thing. So keep that in mind. That was going on for a while. That's still all we have. There's a lot of controversy about the H-2B program right now. Some of you use that program today. DOL is looking at that very, very closely under great scrutiny, and that's a temporary visa program. But again, this is all we have, and we haven't really had other tools. So that's one thing that's been, I think, frustrating right now, because the economy could really be booming if there was a legal program for people to work. All right, so that's all I can talk about visas, because there's not a lot more to talk about right now. So let's talk about how do you protect your company. Most important thing. We always want to avoid knowingly, right at the top. What does that mean? Well, under IRCA, the Immigration Reform Control Act of 1986, you have to avoid, you can't hire, so you can't knowingly, right, knowingly hire someone who's undocumented, and that means without status. So someone comes to you, and they apply to your program, and they say, hey, I don't have status. Do you think the company will help me? But I do have some documents that'll pass. Obviously, we can't hire that person, right? That would be direct knowledge that the person's undocumented and that there's an issue. So that's very important that you make sure your procedures and people who actually hire understand that. How would that come up today also? A more subtle way. Obviously, the way I gave you was a direct way, right? Let's talk about a subtle way. A subtle way is someone comes in and they fill out everything, they get hired, they show you their documents, they go, hey, these will pass E-Verify, and they hand them to you, or these will pass the I-9 process. You'll be like, why are they saying that? Why would they need to say that if this is their identification, right? So that to you should be a clue. That might be a tester. The government sends out a lot of testers to record and video people today, making mistakes in that department and managers. So if someone makes a comment to me like that, I'm going to say, that sounds unusual. Please, we can only do things legally compliant here. And are these your documents? Why are you having to say that? Is this your driver's license, or is this your resident card, whatever it is that they've shown you to verify? And sometimes they'll back away when they've gotten caught. Sometimes they'll say, no, it's my grandfather's, my uncle's, my brother, whoever. My friend lets me use it for now. He's not working. It's okay to use it. They'll say all kinds of things. So be careful about that and just know how to deal with it. Have a protocol. Now, what's the number one protection? So we want to avoid knowingly hiring someone, direct knowledge. And the second part of that is knowingly continue to employ someone if we learn knowledge. So that means that we're going to be aware that if you get a no match letter, an identity inquiry that someone's name or number doesn't match, that you're going to follow up one step further to have an HR investigation and talk to the person and let them know you've gotten a letter from the government, a call from a police officer, a state welfare agency is called and says that you're using someone's social security number who's trying to apply for welfare benefits. All kinds of things come up as potential mismatches or use of someone else's number. And so then you want to do an HR investigation. You just want to bring them in, talk to them, explain that the government or someone has called or said, and we need that you're not using the right Social Security number. We need to verify whether that's yours or not, whether your documentation you presented is accurate. Our company does things in an immigration compliant manner. And then what you do is if they insist it's theirs, to have them sign a new W-4 for withholding, a new W-9 for verification of their Social Security number under penalty of perjury, and then they're allowed to keep working if that's true. And then I would have them sign one more round of those documents, the W-4 and W-9, before you're in, before you issue W-2s, because the IRS requires you to have at least 3 signatures under penalty of perjury if you allow them to continue to work when they insist it's their number. Because basically, when you get information that is an inquiry that their name doesn't match, the IRS that you're supposed to ignore the W-4 form and act as though it doesn't exist and start doing max withholdings and all kinds of stuff like that. So better to follow these steps because little protocols. There's no direct guidance by the government. There's no set law or reg I can point you to. Just over the 20 years we've dealt with these issues, we've learned to develop systems to protect the company and their HR folks so that everyone can sleep at night, no one can get in trouble, and that you have good information. All right, so we're going to talk about a little bit more on that, but I want to kind of give you a big picture before we go through this triangle diagram we have in the PowerPoint today. So PowerPoint 9, avoiding knowingly. Now we know what that means, why it's so important, and that's how we can get in trouble civilly for penalties or criminally, either one. So once we cover that angle, then the rest should fall into place and just be protocols and systems at your company to follow. First one is you put the company, your HR people, your managers, they're in the middle, right? We're trying to protect all of you in that regard. So the next thing we do is look at fully complete I-9 forms. You see that on the left of the triangle today. That means your I-9 forms are your next most important thing to have perfect so that you can't be questioned. You can't have a problem. I guess you question, but there's no problem with that. So what does that really mean? That means we want to learn today tips and details to actually protect you and you have a perfectly, fully complete I-9 form. Now remember today we have a 2-page I-9 form, right? And in that 2-page I-9 form, there's a front page, that's what the employee fills out, there's a back page, the employer fills out. We want it fully complete. Signatures, dates, names, boxes checked, information to the box, to the right of the box if it needs filling out. We want the information from list A to be fully complete on the line, for the title of the document, the date expired, who issued the document, or one from B and C, and the full complete information on those listed. You're not even allowed to put the word BL for driver's license. It has to have the state with it or they can reject it. So each of those rejections on one I-9 costs you $1,000, more than that. So it's important today to grade the papers, I call it. That's our job now. We all get to grade papers, right? But we do have to get it right. Not only is there a monetary fine to that, but if you make mistakes on them and they're incomplete, that's when they can target you for purposes of knowingly continuing to hire someone. So what does that mean? Let me apply it for a minute before we go on. What that means is they see that a card expired. Let's say someone had a temporary resident card or a visa. It expired and you forgot, inadvertent error, but you forgot to do a tickler system. You forgot to keep track of it, and you forgot to call the employee back in before the card expired to say, hey, we can't let you work past this day. You have to actually complete an updated I-9 form and show us documents from A or B and C. You get to pick your own documents. It doesn't have to be the same, but you have to do that or they can't work again. Let's say you forgot your tickler system, and some of you panic on the call today, and you go, wow, I don't have a tickler system. What is she talking about? So you're going to go back and fix things after today. That's the goal, is give you tools and the things we see all the time in all our audits across the country, learn from everyone else's mistakes. Learn what you can fix that you can fix today and start in right away before someone knocks on your door. So that's one of the biggest areas is the card expires. You have like a temporary resident card. Nobody kept track of it. They kept working when they passed that. ICE then jumps to it. Immigration Customs Enforcement is ICE, and they come out and do the audit. They'll say, okay, you don't have your fully complete I-9. Yeah, well, then you knowingly continue to employ the person because you have knowledge it expired as a company, as an entity, and that's your fault. And that's where we get into additional monetary fines of knowingly continuing to employ, potentially criminal, and potentially in some states, you'll have laws that say if you are found knowingly to do those things, you can have higher penalties from the state. They can pull your license. So that's where it kind of dominoes, right? So now you know why I'm not leaving this page yet, because I'm so important. The rest will fly very quickly. But this is a really important point to sink in. The fully complete I-9s are still my best defense to protect every company and every HR manager. I have companies that have 90% of the people, when we do an ICE audit, 90% who turn out to be undocumented. Our HR people did the right thing. They have fully complete I-9s. They have no direct knowledge. We get 0 fines. Okay, so it's still the most important part I can tell you about is that complete I-9. Where you have a gap, where someone forgot to sign it, or someone thought, oh, I don't want to sign the certification, or whatever, that's when we run into trouble. And that's when ICE can say, okay, then you were ignoring things and that's a problem. Okay, so I'm beating the dead horse there, but it's super important. Then on the right side of the triangle, people in common. No discussions about legal status 24 hours a day, 7 days a week. What do I mean by that? Well, what I mean is when we hire someone and they come to the front office and you have your protocols in place for hiring, you've got your new hire packet done, you've done your I-9 form. If you use E-Verify, you've done that. We should presume when they join the workforce, they're absolutely legal to work. There shouldn't be any suspicions based on race or ethnicity, or they have brown skin or speak an accent of any language, or they have a Spanish surname. So we can't discriminate, because that would be ethnicity or national origin discrimination, right? So we can't have a manager come in and go, hey, so-and-so is going back to Mexico for Christmas. I wonder if he's undocumented. Are we really sure about that? That would be when you sit down with that person and go through an anti-harassment, anti-discrimination, retaliation training as an HR professional or manager to say we don't make suspicions about people. They're all authorized to work unless they've told us something or we learn something different as they're employed and we go back and investigate. But targeting people based on the color of their skin, the language they speak, those kind of traits would be discrimination. So we don't want to have people doing that, but thank you for raising it. But we want to educate you about that too, and make sure your manager or employee goes back to work and understands not to target people or make jokes about it. So this comment I put up here is so important because I used to have a lot of companies where the managers, the first-line managers are construction, superintendents, foremen, all kinds of people make casual comments, restaurant managers. Like, I wonder if so-and-so is legal or not, We got to treat that like when you go to the airport and you're at the airport and someone mentions the word bomb. What's going to happen to you? You're going to get handcuffed and TSA is going to visit with you, and it's not a good moment. You can't joke about a bomb. They don't take jokes. They take jokes seriously. We want immigration status to be the same thing at our company. We want to have our protocols up front for hiring, the new hire paperwork, the fully complete I-9s, and then we don't talk about it. There's no reason to ask about it. There's no reason to be targeting people. That would be discriminatory under the civil rights rules. And the Office of Special Counsel, OSC, the Civil Rights Division of the Department of Justice, DOJ, will come and do an investigation, and they will charge you for targeting people, as well as the EOC. So there are reasons why companies have to walk a fine line. Again, we want to put the company and the managers in the middle and the HR people and protect you on both sides. So on the left side, I want to fully complete I-9 done. On the right side, the EOC and the Civil Rights Division, the Department of Justice doesn't want you to target people. So keep that in mind, okay? That's part of it. Now, what else do we do to bolster and protect the company? Number one, on the bottom there, responding to government investigations. How do we respond? What if someone shows up? What does it mean? So we're going to go through that today. We've given you those tools today. How to deal with an ICE investigation if someone shows up. We're going to give you those tools today. You're going to have all this before you leave. How about crisis communication plans? How do we deal with that? We lose people. Like I mentioned, sometimes I have companies who lose 90% of their workers. What do we do about that? How do we deal with that? So that's something we have to deal with also. So keep that in mind. So we have a plan for all of that. Now, responding to inquiries. Remember how I mentioned that we get police officers or your state employment agency or welfare agency that's going to call, and they're going to say, hey, someone's not using, or someone at your company is using the Social Security number of one of my family member. talk to the current employee. And then a lot of times we tend to send those letters for companies all over the country. So we like to not have company employees, HR people's names on them or payroll people, because those are the first line for subpoenas and things that the police and everybody uses who signed the letter, right? Plus, we kind of need an official letter, right? Like if I'm calling your company, think about it. I'm a mother, young mother maybe with a 2-year-old, and I'm going down to get, maybe I'm going through a rough time, I need food stamps, and I need Medicaid for my child. And I walk into things the first time in my life, and they say, hey, your son, who's 2 years old, is working at this company called whatever, Construction A. And they're working, so we can't give you any food stamps, and we can't give you any medical help. And some states have a requirement that when that happens, in order for that person to get any benefits, they must file a police report and start an identity theft investigation with the local police department within 24 hours if they ever want to get any kind of benefit. So we try to teach you to be responsive the minute those folks call. And I'm going to show you a script about that in a moment. But that's a really important one because we want to give them an official letter, which is why we have 20 different templated letters. And depending on who's calling and what the circumstances are, whether it's Social Security Administration or welfare, police, citizens, mortgage verification, whatever it is that cause a discrepancy, we have a letter that goes. It's a different letter if it's a current employee or a different letter if it's a former employee. So we teach management and companies never to actually, never to give information over the phone, okay? Very important that you don't give information over the phone, meaning you don't verify for people whether somebody works there or not, whether they're still employed, whether who's using the Social Security number. You just want to be, thank you for bringing it to our attention. We will follow up with that right away. Please let us know and we'll address it. Please will give us the time to do that. We'll do it right away. We like to send those letters. How fast? Within 4 hours from our office. Because why? It's an official looking letter, our law firm letterhead. It tells them something, but not everything. We don't give them all the details we have companies send us. But it's a letter they can use for the next 20 years of this kid's life. So if I'm the young mother who came in with a 2-year-old, guess what? They're going to have this inquiry come up with this other name and information, Social Security earnings and all this stuff for 20 years or more to explain this circumstance. So we do need to give them an official letter that helps everybody out. It happens after the IRS every year issues the taxes because someone will go in and they're pay their taxes and the IRS says, hey, you didn't pay enough taxes. And they're like, what are you talking about? This is all I earned. And then they're like, well, you worked at 4 other companies because we have all this evidence and wages and they borrowed your number. So this is a really frequent occurrence. All right. Social Security no match, same thing. Responding to customers or third parties. Again, new hire packet, very important. We like to have an immigration compliance acknowledgement form in there. We like you to use W-9 form. Again, W-9 form is verification of their Social Security number under penalty of perjury, right? That's different than a W-4. W-4 focuses on withholding allowances. Why do we like a W-9 form? Well, we never know if something's counterfeit or not. If someone shows you a Social Security card, you're not going to generally know. W-9 protects you, and I've used it for 20 years. And so in the 1990s, when ICE took them out, and it was INS back then, and did all these raids and criminal investigations, and it was a real dicey time, and I handled many of those in that era. So I learned to be more protective of companies from that time period. Is what do we use to show that our company and management team and HR team relied on something, and it was the W-9 form. So you're used to using it for independent contractors and like 1099 folks. You use it differently here. So you check the individual box, and as an employee, I sign it along with the W-4, so they're just payroll forms. And then we keep it in the file, the regular file for this document, and it's basically lets us know that we have a legal basis to not have knowledge, that they're not undocumented, and that it's really them. So that's all you need. And we're not allowed, to ask for Social Security cards. It's up to them to show them or not with their I-9 documentation. So some companies were going out years ago, and the IRS was like, if you turn something in and it doesn't belong to that person, we want to charge you $250,000 a year for turning in Social Security earnings that are not theirs. Well, they said, go ask for a Social Security card and only turn in wages based on that card. Well, we can't do that. And that's been long past anymore. We can't do that because we have to pay people based on the name, on the documents, and on the I-9 form. That's their pay. They may not match the Social Security Administration, and it doesn't. 17% of the country doesn't match. Their name and socials don't match. So keep that in mind. that the W-9 is what protects us. It goes with the I-9 form, but not together. But it protects you because that's how you're paying them, and that name better be on the I-9 form. And it doesn't matter their Social Security name and number is different. It does mean they have a problem, right? Because when they retire, if they're not paying attention to their name and going to Social Security and fixing it, which you're not doing, that's not your job. And we give them a certain letter for that when we learn about it. It's up to them to take care of it. They're going to have to sort out whether they'll get the earnings. But that's why we have billions of dollars in unapplied earnings, because so many people have worked in this country and it doesn't apply to them. And then employment policies, anti-harassment, anti-discrimination, I mentioned those. You want to avoid national origin discrimination. All those things on policies you want to update and make sure they're clear and that you teach on it in your new hire training and orientation and throughout the company over time. Agreements with leased employment agencies, be very careful about that. Make sure you've got a provision. If you lease employees, you better make sure that you've got a provision that they agree that they comply with immigration compliance as well as wage and hour. They go hand in hand. We deal with a ton of DOL audits right now. They've just escalated everywhere in the country. So these two go hand in hand. And if you're hiring leased employees from someone, temporary employees, you want a provision on the risk on that basically covers you that they are agreeing to the immigration compliance, they're following the I-9 forms, wage and hour, all the rest to protect you. Contract provisions, watch out for that if you're having labor shortages in your area, which is a very big issue for all of us in America right now. And then attorney-client privilege conversations. Sometimes you just need to call and talk or email. So be careful that you know that when you're having conversations about identity theft, when you talk to your accountant, or you talk to a local HR consultant, you talk to someone locally, and it's a really dicey question, that's not a privileged conversation. You want to be a little bit sensitive to knowing the difference on those if there's a concern. And what's a concern? When your executive comes to you and says, hey, I've got a live-in helper who's working as a nanny and a housekeeper in my house or my guest house, should I have a concern about that? Don't go talking to the world about that. There's all kinds of privileges that need to be protected in that. Because they can, if you have people and you're harboring people who are not authorized to be here, they can take your assets, they can take your house, your company. Some have had some companies buy apartment complexes to rent to people. Cars they're transporting people, and those can be problems. Because ICE is going to say you're harboring people, and that gets into a criminal as well as a seizure situation. Okay, let's talk about, we're going to go faster now. There you go, you've got your foundation. All right, first step. Responding to government investigations. How do we do that? Well, if you're approached by a government officer, OSHA, ICE, we do a lot with OSHA. They come into, OSHA is not disclosing generally information to ICE or FSA or Wage and Hour Department of Labor. But ICE and Department of Labor have a sharing agreement and they do share information, so keep that in mind. Anyway, let's just learn the script. You see it involved there. I'm sure the company will cooperate. However, I am not the person to provide you that information. Let me get my supervisor or a lawyer who can work with you. All right? Very easy. That's what we always say. And then if the police officer yells at you and says, I want everything now. I want to see it right now. What are you trying to hide? Sometimes we even have them come in and say, I want every Hispanic person's personnel file on that desk right now. Sometimes they say it much ruder than that. They'll say, I want every Mexican's personnel file on my table. That's all discriminatory against the law, but that happens. Okay? So we have to cover it. So again, the receptionist at your front desk, now terrified with this person yelling at her, just goes back to the script. I'm sure that it's on PowerPoint 11. I'm sure the company will cooperate. Again, I'm not the person to handle it. Let me get some information from you and get someone who can help you. Okay? That's how we do it. So keep that in mind. And we just teach that over and over again. It's a document people can pull out. They don't have to hide it. When an officer comes in or someone else, they just say, look, our company has a protocol. Can I pull out that document? Can we read it together? It's not my area. And that's fine. They're used to seeing these. These officers are seeing these everywhere. But a couple other things on PowerPoint 12. Find out what agency they're from. So many people call me in a panic. They're called to my team, and they don't know, and they're panicking, and someone's standing right over them, and they don't know who it is, or they walk out the door, and they're not sure. Make sure you know what the insignia says. Ask for a business card. Watch out for plain clothes people. Sometimes you have to ferret out imposters, bounty hunters. I had one poor client who had very strict rules on this. And then what happened was they had someone come in the front door. It was a very small front office, but a big facility. It's a big framing company. And the guy came in and he said, it was someone else that said, my mother has a heart attack in the hospital. We're supposed to pick up my brother. We have to pick him up right now. And so it was in a panic, and the front receptionist was like, oh my God. And she went and got the guy out. And as soon as he came to the door, the guys grabbed him, put him in the car, and went and killed him. And they were wanting money from him, and probably coyotes for weekends. Anyway, so those things happen. You want to have protocols where people do not confirm when people are working, who's working. We have a lot of domestic violence situations today, so be careful who's asking questions. PowerPoint 13 just gives you more information to remember. Again, if they have a subpoena or search warrant, we're going to cooperate with those two items. You don't want to obstruct justice. But again, contact the company's designated person. If someone has a subpoena or search warrant for your company, get your company lawyer involved right away. ICE shows up on PowerPoint 14. It talks about that. You have a 3-day notice for documents, okay? So they're going to show you and give you 3 days. Do not waive those 3 days ever, okay? Do not voluntarily give up anything at that moment, okay? Don't give admissions. Don't talk. Usually, ICE can be pretty good to deal with. We have a really good relationship with them. In some parts of the country, they're a little more territorial. They have different perspectives. And so you will run into officers just like everywhere in life. There's people everywhere. Some are much more bullying or targeting, and so you really got to hold your ground and be professional. If someone's really being out of line, just get the company lawyer on the phone. Usually we can calm them down in about 1 second on the phone, but normally they walk in, ICE will give you the document, they'll ask you to sign it, so you're not waiving your 3 days, you don't waive that, and then they'll ask to pick up the documents within 3 days. And most of the time, we don't usually have them come back to the company site. We usually pick them up or we send them to them, FedEx, or drop them off where they come to the law office or whatever is the location. But we generally don't have them come back to the offices at that point. So just keep that in mind. You want a copy of everything that they take. You want a receipt for every single one individually by name. So there's a whole process for you to get that. I have had people just give them their original and they're lost, or they get misplaced, or they come back with charges for penalties against you, and lo and behold, you don't have any evidence or record, okay? So that's why it's important to do it properly with the chain of custody and to protect your own company. If the agent has a warrant for the arrest of an individual, don't obstruct justice. Work with them and cooperate with that one item. If they have a search warrant or a subpoena, you can ask for and keep it. You can get a copy, comply with the warrant, attempt to maintain a list of what they take. Again, don't obstruct justice, but work with them on that. And don't argue with this or get into a confrontation. And again, contact the company's lawyer on any kind of subpoena against the company. But don't give them more or different information and don't waive your rights on it. It has to be just what's in the subpoena, okay? All right, what if the agent requests, it could be government, anybody, law enforcement, they request social security numbers, I-9 forms, documents, things like that. They come in the door and they say, I want these right now. Well, again, you just say, I'm not the person authorized to handle it, but I would be happy to cooperate with you. And let me get my supervisor who can help. Resist the pressure from the agent to provide them right then, or even to confirm if they work there. Sometimes they'll just say, well, just let me know if they even work here, okay? So you want to be careful about that as well. Don't be confirming things, because again, you don't know who everybody is. You want to follow the same protocols for everybody, so we're not targeting or discriminating. But again, we'll get back with them right away, and we're always very responsive. You'll be able to implement the same protocols, so just keep that in mind. Immediately forward any Social Security discrepancies to HR. HR will conduct the investigation into any identity theft or any allegations about that. You may need some legal counsel for privilege depending on what it is. Most important is item 4, though. If an individual calls and says that someone's working at the company using their name or their kid's name, you want to get this information, because that's the fastest way for everyone to respond. We always teach our clients, these are the 4 things get the receptionist to get from them if they call them. The name of the person, or their kid, if it's someone else in their family or spouse, and the social number that's being used, the telephone number, the mailing address, or email address. And we prefer email to do it as fast as we can. It's the fastest way. We like to get these things out of our office in 10 minutes and not a big deal. So we always have the company send that information. You send the W-9 form, their I-9 form. We don't send those to the person making the complaint, but it helps us understand what's happening. And again, what you want to say to that person who calls you, whether it's an agent and a police officer or calling you, is I'm sure the company is happy to cooperate. I'm not the person to provide you the info. Let me get some information um, from you so I can get the person who can handle this for you. So basically, you want to sound eager beaver on top of it, and we're going to follow up right away. That's the most important thing. Because remember, they need that to get benefits and other things. Okay? Very important process there. And remember, the government doesn't give you any process on how to deal with that. So there you go. We wish, but we have developed these over the years, so we've learned what makes sense to do. All right, next. IRCA. Remember I mentioned 1986 was when we had the Immigration Reform Control Act come into play. That's what requires the I-9 form to be completed. It came into play with what was an amnesty program, people call it that, back under President Ronald Reagan, where we had so many people in the country who'd been here for so many years, and they were required to bring things in to prove they were here and that they were good citizens and paid their water bills. They brought all kinds of stuff. And they were able to apply for a program to get status in this country. But Congress at the time, under President Reagan, did not make any provisions for the future growth of the country and how to put, how people could apply after 1986. So it really captured everybody at that moment and then no one else pretty much. So that's what happened. But in exchange for that, they started the I-9. That's where it came from. They're going to give them an amnesty, and they want companies to do I-9 forms. But this is also why people who work for your company before November 6, 1986 do not ever have to complete an I-9 because they're grandfathered. So that's where that comes from. What does IRCA do? Item 2 on PowerPoint 20 talks about how this is what you can't, you hire, prohibited conduct is hiring or continuing to employ an individual knowing, remember that knowingly we talked about? That's what we're talking about. This is the law on it, because they're not authorized to work. You can't hire anybody without completing an I-9. You're supposed to complete Section 1 on the beginning day when they start work. And you can't discriminate on the basis of national origin or citizenship status. People make that mistake all the time. A Form I-9 must be completed for all employees to confirm eligibility to work. You follow the instructions. Put dashes if it doesn't apply. Remember that in Section 1, the employee that fills it out, under Item 3, it tells you in the note here, the email and phone number in Section 1 is optional and generally should be left blank. The government does call people when they fill that out. So a lot of people don't like that, and employees get mad if people in the government have their personal email and phone number. So keep that in mind. It's optional. Item 4, no extraneous marks, stamps, or information. We do so many I-9 audits, and I can't tell you how many people have stamped stuff. I had one company who stamped in red all over the place, audited, 6 things, audited. That just is a big red flag to the government when they walk in, that you've got all kinds of problems. And then if you didn't get it right, they hurt you worse for penalties and consequences if you tried to fix your I-9 and did not get it correct. That's worse than having had it incomplete in the first place. So then they say, look, you picked it up, you had knowledge, and you should have fixed it. So be very careful. If you're going to put something on the I-9 extra, like how about your e-verification number if you do e-verify, or your employee ID number is a common one. Put it on a Post-it note, put it on top of the document. Okay? That's very important. So keep that in mind. No marks, no stamps, no information. Don't do a big highlight that you audited things. There is a proper way to audit them, and we'll talk about that in a minute. But don't stamp them and stuff. All right, what are we required to do? Well, most of you are familiar with that. Employee completes Section 1. Must be completed the first day an employee works. And you cannot request documents to verify the information in Section 1 as an employer. So you can't say, can you show me that permanent resident card? You just check box 2 on or 3 on, on the form. That's prohibited. The employee fills it out. All we can do is look at it, make sure it's fully complete, and that's it. The employer completes Section 2 within 3 business days after employment begins. The employee selects which documents to provide, but if you use e-verify, the listed document must contain a photo. Now, what's the most important thing that all of you do on the phone? I mean, today, what you do when you're filling them out? You must testify under Section 2 by signing that you saw, touched, and felt the original ID documents to complete Section 2. Now, why do I emphasize that so much? If you can say that, you can't be targeted by the agents of having knowledge or having done something wrong if you have no other knowledge. And here's why it's important. First, you're not expected to be a counterfeit police, okay? You don't know the latest rings. You don't know what to look for. You're going to be able to see obvious things. If someone Scotch tapes a photograph over a driver's license of someone else, well, you know to reject that and say, I can't accept it. That doesn't match you. You know about the E-Verify photo tool if you guys use E-Verify, some of you on the phone today. Because on E-Verify, your photo tool will match on the computer the photo in the exact way it is on the employment authorization document. If it doesn't, you can reject it. You just say, I can't accept this because, but it doesn't spell right, the photo doesn't match. However, if you show me another document off the list, either one from A or one from B and C, I'd be happy to consider it. And you only do A or B and C. It is overzealous and document abuse to do A and C or A, B, and C. That is where you get in trouble also. So no good deed goes unpunished. You can't be overzealous in this area. There are really consequences to all of it. All right, photocopies are not acceptable except for a certified birth certificate with a raised seal, right? So what else do I emphasize on this page about the touch, see, and phone? Where I see companies mess up is where someone in the field, let's say you have a remote location, says, I'm looking at the document right now, and they call someone in the office who's an HR payroll is in charge of filling it out, of the office person, and they say, here, fill it out. I'm reading it right now, trust me, just right up. That cannot happen, ever. That person who's actually touching and feeling it should be trained up, and they can be in the field, and they can be a manager if you really want them to. It's better to centralize where you can, but that can happen. They would have to sign it because they saw it, okay? Now, one quick moment here on the new I-9. We had hoped when HR Simple put this together today. We had so hoped the new I-9 form would be out today. So what do we know about it? Well, when you look at an I-9 form, the top right corner is the expiration date, and it says 3/31/16. So it expired March 31st, this I-9. Does that mean that we don't have to do any more I-9 forms? No, we just keep using the same form. However, the new one's coming out. There's been questions about it. We'll roll out a quick hot topic on it when that happens, so stay tuned, HR Simple on that. The book will be updated, so everything will be out as quickly as it's issued. But for now, you use the existing one. Just know that any day now, and within a month, I would hope, we'll see the new one. So there we have it. They did publish the draft of the new one, the idea of it in November 2015, and requested public comment. So we're just going to have to see when it comes in. There is some discussion the proposed I-9 form would have an electronic component to it, but you still would have to print it and have them sign it manually because they don't, unless your company uses an electronic signature program, which has its own requirements. So again, if you use electronic I-9 programs, we have special requirements and a process that has to be met in order to qualify. If you do electronic signatures, because you have a lot of remote locations, that works too, but you have to have certain requirements to be able to have a valid government-approved employment signature, or to really qualify for an electronic signature. The other thing is, on the new I-9 form, it'll have electronically, it'll have little boxes pop up. It's supposed to help you not miss the wrong box being checked, those kind of things. So I'm not going to go through it a lot in detail right now because we don't have the final. We're not sure what it'll finally be. It will have a prepare a translator section just like the normal I-9. But again, item 5 on PowerPoint 26, it still requires you to print and sign it if you don't have a valid electronic signature program. All right, let's talk about the current I-9 notes. You have to go back and audit, right? So after today, what you want to do, we're going to give you the tools today. If you want help, we're always available, but you can do it on your own after today. So the I-9 form, what you want to do is take a list of your current employees. This is how I always start every audit when people have an audit. I want a list of all current employees, and I want to then match up an I-9 for every one of them, unless they worked for November 6th, 1986, and they're grandfathered in. So it's not going to be a lot of people. There might be something. Then you're going to make sure your I-9 exists and it's fully complete for every single person, and that's just how you do your audit. I don't like to make any spreadsheets of all the errors and to keep a list like you normally would in your wonderful HR professional way. That's a very dangerous tool that the government can subpoena and use. So we tend to do them in piles, and it's done to show work. I mean, sometimes outside consultants do it. It's not a good idea. You just want to show the work, meaning put post-it notes or stacks. And I usually stack things in 3 stacks when I do them. First stack are those that are perfect I-9, fully complete, great. We don't always get as many in that stack as we all like. Stack 2 is all the ones that have to be redone, okay? Redos, meaning someone didn't sign it, someone didn't put the card on there fully complete, someone didn't fill out something. That means we have to go back and redo them. It may just be one question or section, or maybe the whole I-9. We'll talk about that in a moment. Then we have Pile 3. Pile 3 is an education I-9. And what do I mean by that? It means we're not calling the employee back in to redo it, but we didn't do it right. And we need to be aware of that. So, for example, maybe our company representative was overzealous. They put in something in A, B, and C for the document. So A and C. That's a mistake. That can be a violation, but we can't really fix it. It's already there. So we have to remind ourselves to tell everybody, don't ever do that again. And from this day forward, we can say we honored the I-9s and that mistake never happened again. So things like that. So the main pile we deal with, let's go back to the middle pile, which is the one we have to redo. So when we're looking on the screen right now, I'm putting up PowerPoint 27, it shows you that the section 1, let's say the last name, first name, the address, maybe, let's say, for example, the person forgot to put their date of birth. Everything is filled out with that. To go through, we do our audit, we go, darn it, there it is, the date of birth is missing, right? So then what we do is we have to call the employee back in and have them write their date of birth in, and then initial and date it to the left right there on the side, because we have to have an audit trail. So ICE can see that, okay, you had an I-9 on file, properly filled out within 3 days of when someone started work, and then the employee section filled out on the start of work on the first day. The employer gets up to 3 days to finish it. And that you modified it. You went in and did an audit, and you signed and dated by the employee there and filled it in. So they can tell right away that that's what happened. Let's say they wrote the wrong thing there. Let's say you looked at it and you went, wait a minute. For date of birth, they put today's date, whenever they got hired. In that case, if everything else is complete and all that, you can go back through and do a strike through right in the middle, single line, so it can be read what your person's talking through. Then below it, the employee write the actual date of birth and initial and date it again. So it's very important to track to get the flow of that, the audit trail, so the auditor can see what you changed, it wasn't backfilled in, those kind of things. All right? All right, that's section 1. Again, the email address and phone number are optional. I don't, you want to tell employees that because they really don't like the government gathering information about them usually, and it's not being done for your purposes. Again, the employee must complete section 1 on the first day of employment. They added extra fields on there. You guys are probably used to that for the tear-off cards or for the passport information if needed. So it's just a longer page. You guys have seen this part. It's got 4 boxes to check. It's tried to make it clearer. They do electronically scan these today. That's where they talk about the barcodes and all that. But it is supposed to be easier to fill out because there's so many mistakes before. So they either check the box for a citizen, a non-citizen, a lawful permanent resident, and put their alien registration number or USCIS number, or an alien authorized to work and kill. So those are some of the things here to fill out. And then notice they sign and date it at the bottom, right? And then that's it for them. You double check it's there. That's all we have to do. They made a few changes. Again, it's electronic. The I-9 system is supposed to become electronic, as we know in the new version. Signature box was redesigned to help prevent employees from signing outside the box, because we all know we have that problem when we went and audited before. Then the bottom of section 1 is to prepare a translator certification. Then you stop at the bottom. Then it's your turn on the other side. Now, when you look at this prepare a translator, we don't want to fill it in just to help them understand a few little things. If they really can't read or write and you have to fill it in, there's nothing wrong with the person, manager, HR person filling that out. If they bring someone with them, they should fill it out, okay? It's important to help them do that. But I wouldn't do it just because you're showing a document in Spanish to them and saying, here's an I-9 in Spanish, here's what this means, fill it out. That, don't go be overzealous on including your name on there if you're not really helping them much. But if you're having to write it for them, that would be the circumstance to do that. So just keep that in mind. And speaking of prepare a translator for just 1 second, there is a Spanish translation I-9 from Puerto Rico online. You can use that, but you can't fill it out on that. So use it means here's what it said in Spanish, so you don't have to redo it yourself. And then if you want a Spanish version, for example. But in America, outside of Puerto Rico, you have to have the English version filled out. And it's a little quirky. Everyone looks at it as an official government form, but that's the story about that. If you go back and audit and find you have a bunch of Spanish ones, you'll have to redo them in English. And that's, otherwise it's a citation. They're fine. Okay, section 2, what are you doing? All right, well, what's the most missed item? $1,000 a piece, what's the most missed item? Employee last name, first name right there. All right, in the new form, they're going to fix that so people don't miss it, because that's been the most missed item. And ICE prefers, as a best practice, that you actually do these I-9 forms double-sided. Okay, that's really what they want. So they want the last name first. That should match the first page, whatever the person wrote. What else is it going to match? It's going to match your paycheck and your time card and your name badge. Don't have people using a variety of different names. That's how we get into knowledge and wondering and all those things we want to avoid. So keep that in mind. Their social security card may not match these names, but they had ID documents that matched it. It's on these forms. That's what you pay them in. It means we're going to get social security no match letters. We have a way to deal with it. But we can encourage the employees to fix it, but they don't have to fix it. So keep that in mind. Notice we have a list A, or that big black line there, B and C. So list A, you fill out document title, issuing authority, document number, expiration date, maybe it's U.S. passport, whatever, permanent resident card. The permanent resident card means the perm resident card. Because a permanent resident card, you don't have to really verify if it expires. Okay? So it's important. If you forget to put the word perm up there, you just look at it as an EAD card, employment authorization document. We don't know if that's a permanent card and it expires. Now we have to call the person back in and redo it when it expires. And if someone's card's expiring, I prefer a practice, a protocol of a 90, 60, 30-day letter being sent to that employee before the card expires. So they have plenty of notice to fix it. They have plenty of notice to know the day they're not going to be able to work one day past. The date expires. They can be on suspension without leave. They can be let go and then rehired if they can get it fixed. So we want to alert them. It's like letting them know it's fixed. So keep that in mind as one way of keeping track of them. Every document you accept must be current when you accept it today. Today, that's the rule. It wasn't the rule in the past. That's the rule today. But if U.S. passport, permanent resident card, all has to be current. You only have to keep track with the tickler system of some documents that expire, and the temporary resident EAD cards are those. That's one of them. So keep that in mind. Again, the I-9 form section 2 must be completed within 3 business days after the employee's first day of work. You'd like to do it the first day, but what if the employee forgets the documents? Stuff happens, right? So that's what it means. Again, print the I-9 double-sided. Do not record extraneous information in the excess space on the Form I-9. Now, your certification, I already mentioned that. You're saying that you touched and felt the real card. You don't have direct knowledge this person is unauthorized to work. And the card does appear to be genuine and real to the employee. You're not the counterfeit police. There's no good standard for that. It's just what you think. So what would I reject? If something is misspelled for your state on the driver's license, then I would say, oh, they misspelled, North Carolina wrong. I can't accept that card. And sometimes the government actually misspells the words. Sometimes I've had employees say my name's misspelled, things like that. So that becomes an issue. The employee's first day of employment needs to be written there, and then you have to sign it and date it. You are allowed to pre-fill only certain items, and if you want to, you could. This is a fillable form, and you can put in your title. You can print your last name, first name. Also fill it in for your company name, your address, your city, state, and zip. The 3 things that would be live signatures would be the signature and the date signed. Those you would have to leave as written at the time. But keep in mind, you need to have blank ones in your drawer or around, because what if you're not there? And if the only ones you have are these, then it's going to be filled out wrong. So just keep that in mind. It's important to have them available. And again, watch for misspellings on cards. Make sure the photo on the card matches the employee so that you can say it was them. Sometimes you'll have young people borrow their grandparents' cards to work, okay? So they'll bring them in and try to pass them off as their own, and that's where you run into problems too. So again, as long as you're touching and feeling the real card, you shouldn't have a problem. All right, section 3, what's that about? Well, with a new hire, you don't touch it, so we're done. But if you go back and you have people who get rehired, or they change their names, or they're re-verifying because the document expired, then you fill out this document. If you ran out of room because they worked for you so long, they have multiple expired documents from the visa programs they're using and things like that, then you just do a new I-9 form on top of it and put them together. And the other thing I need to remind you here is, where do we keep the I-9 forms, right? The I-9 form cannot be kept with the regular personnel file. They have to be kept separately from the personnel file. So just keep that in mind. The I-9 form and any verified documents that are behind it, they all kept together. So keep that in mind. Let's see what else. Oh, I know one thing here. So a lot of times in the past, when people got divorced, married, they changed their name. A lot of people use Section 3 as the way to update it, and that's fine. then you have something on file. Make sure they update to W4 and W9 too. That's a fine way to do it at all. PowerPoint 40, most important lesson I can give you today. Make sure the company has a tickler system for expiring work authorized documents. Very, very, very good. Okay, so keep that in mind. We cannot allow an employee to work after it expires. That's when it becomes knowingly continuing to employ. That's how it all ties together. So keep that in mind. Receipt. Okay, Social Security. What do we do with that? So if people come in with a Social Security receipt for a replacement for lost documents, you are allowed to write that on the form, and then within 20 days they have to show you the real document, and you cross through with a single strike, initial dated, and then you write in the actual card when it comes in. But you are not allowed, that's not allowed, to accept a receipt for an application for Social Security. Okay, so keep that in mind. Those are two things there that people make mistakes on. Use black or blue ink generally, easier to photocopy. No whiteout, scratch out, or mark throughs. Don't use different color ink in the same section. Why do I say that? The agents look at that as there must be something up, that you've modified it later and you're trying to pull one over on them. So keep that in mind. So these are just some general overall tips. Write your dates as month, day, year. If a new form is redone, remember how I said you'll have to go back in that one pile and redo some? You want to keep it with the previously completed I-9 though. Okay, you do keep them together. And if a mistake occurs, just complete a new form if it's at the beginning of the new hire stage. If you see a lot of mistakes and the employee's still sitting there, just shred the first one and start over. But if a mistake occurs and you notice it later in your audit, then you're going to call them back in and do it at a later time. I mean, you're going to redo the I-9 form. Now, when you redo the I-9 form, it does not mean that you have to call the employee in. It depends on what it is. If you just forgot to put your title, for example, as maybe the manager or HR person filling it out, well, you may just fill it out yourself initial and data. We don't have to call the employee in for that. But if it's in section 1 and they forgot to sign it, they forgot to date it, they forgot to put their birth date in, you need to call the employee in to do that. Okay? So just keep that in mind. And many times, if you've gone back and redone your audit, here's the good news from today. What will happen is you will generally not get a citation for that or monetary penalty for that. So keep that in mind. It's been very well received by ICE. If people do their own audits, they fix everything by the time they come in. But again, they are more critical where you tried to fix them and you did it wrong a second time. That's the worst situation. But where you get it right, that's fine. And sometimes a good way to do that, if you don't know, is sometimes people just set a 30, 40 at a time or stack and say, here's what we did, here's what we're doing. Check a few and make sure we're on track. Because if you're the one doing it, you don't really know the mistakes you're making, right? You think you know, but we all need a second set of eyes. That's the thing there. All right, what else? Here's a little common mistake people make. Post office box is not accessible. It has to be a physical address, so keep that in mind. Write out the full city name. Birth certificates have to be listed as certificate of live birth or whatever it says on there. And again, that's the only kind of photocopy you can accept with a raised seal. So keep that in mind. Record exactly what's written on the document. You do not need to keep photocopies of documents used for ID unless required by E-Verify because it's a photo tool document. Some states have real ID, so that might include a driver's license or might not. Some might be the employment authorization document. Or a state may require it like Colorado, but you don't keep it with the I-9. It's kept separately for that purpose in Colorado. Again, make sure it's fully complete. Write them out. Don't request documents to verify information in section 1 by the employee. Remember that. And I already covered this a little bit, just a few reminder points here on general tips. You use one document from List A or one from B and C, and the difference for those today who are participating who use E-Verify is that your List B document has to have a photograph. So keep that in mind. It would have to have a photograph. Now, the document must be unexpired at the time. I already mentioned that. It has to be a current document. Couple tips about that. Sometimes there's an auto extension on the federal website for some individuals based on their employment documents. And we gave you the website, so that does happen. You want to print that out and keep it. Sometimes a high school ID expires the year after it's issued. If a document doesn't have an expiration date, draw a line or put NA in it to make it clear there's no expiration date. Okay? Do not accept Social Security card that says valid, not valid for employment, or valid only with DHS authorization. That usually means it goes with something else. The number is probably fine to use, but you can't use it for a List B document. So I think that's clear to people today. It's on the form that way under A, B, and C, but just keep that in mind. Do not accept photocopies. Again, I can't say that enough. I can't tell you how many times that's been a problem. And I mentioned also write in your document title, issuing authority, and document number. If there's no expiration date, put a line. Same person completing section 2 must be touch and seal. I said that 3 times, so hopefully there won't be a mistake anywhere after the day. It's deliberate to do that. That is the most missed item that opens the door to criminal allegations and civil. Receipts for documents, again, you can only use an application or receipt for Social Security card for lost or stolen, not for an application for one. And then you still have to update it within 90 days. That means you need to add to your checklist system that type of document as well. And usually the system we suggest as a recommendation to do that with one or more persons having access to it. So if you're on vacation or something, you don't have an issue there of missing it, okay? We talked about the notes. Don't make notes. Don't accept a permanent resident card from someone who on section 1 checks the citizen box. That would be an obvious thing. So you want to say, hey, this doesn't match the box you checked on the front. You need to relook at that and do it correctly. Don't accept a U.S. passport from someone who attests to being a permanent resident in section 1. So people make mistakes. They're human about it, but just have them fix it if there's a mistake and ask them to check the correct box. And again, for your audit trail, initial and date. I-9 retention. All right, what's going on there? This is the rule. Remember I said I-9s are kept separate from personnel files, but then the question is how long do we keep I-9? So, personnel files. Generally, first of all, you're going to keep all current employees' I-9 forms. That's why I put in bold, all current I-9 forms. But when someone leaves your employment, they resign, they are terminated, usually people take the personnel file completely, they close it up, and they put it in a storage shed for 7 years, okay, or put it online, whatever. Keep it for a time, and it goes into the retention hole at the end of that. It's gone. The problem is we do not want you to keep the I-9 forms with that stack. We're going to get rid of them as quick as you can legally, assuming you're not under an audit. So what does that mean? Well, you keep them a max of 3 years for a current employee once they leave your employment. So it'll be a 3, 2, or 1 year rule, and you just follow this formula, and you have a little tickler system. People mostly do it on a rolling 12 months and just put in a file drawer or some system like that, place like that, and it works great. Just keep that in mind. It's one of the things to go back and do. It's important not to keep them longer. If rehired within 3 years after date the original I-9 is completed, the employer can complete section 3 of the I-9 after verifying that section 1 is still accurate, and you can use it. If more than 3 years after the original I-9, just do a new one. If they previously completed section 3, so it's all full, just complete a new I-9. That's, an easier way to do that. And one other thing, you can just have a rule that every person who comes in the door to be rehired is a new I-9 form, and it just makes it easier for you. That's fine. If the employer uses E-Verify, create a new Verify case. If the employee did not go through E-Verify on the original hire date and they're now rehired, or create a new E-Verify case if it's been more than 3 years, or if the documents have structure. So that's how you would do that. Again, to protect yourself, recommendations regarding I-9 forms, do training like you're participating in today, save your summary that you will hear today. Self-auditing I-9 forms, anti-discrimination policies are important. Your record keeping, don't keep I-9s longer than you need to. And consistency on how you handle matters. So other quick points on self-audit. They did do a summary, a guidance on some of the audits when you are doing them internally. What you don't want to do, when you're conducting internal audits, you cannot do it only for non-citizens. Okay, that would be discriminatory. You don't just target people who are non-citizens. You don't want to even go there. You just do I-9s for everybody you see. If you require non-citizens to correct errors, but you don't require citizens to do so, that's discriminatory. If you audit employees' forms because the company has stereotyped employees as potentially unauthorized because of their race, their language, their ethnicity, where they go for the holidays, that would be discriminatory. So anyway, these are concerns. I'm just pointing these out as treat everybody fairly. Don't talk to people just because, they're forming a union and they're talking. I'm going to go see if I can get rid of them all. Let's just go do an audit on them. That could be a problem. So don't want to do that. And again, some of the ideas I think we've covered this pretty good. I think you've got that down. If you have to audit something on the I-9 because it's incorrect information, just draw a straight line through it, okay? And you can correct them that way, and so this just gives you a couple of points on that. Do not use whiteout or scribble out information. Again, show your lines and your strike through so that you can do it. Multiple errors, just do a brand new I-9 form, attach it to the original one. It shows you did it, and in most circumstances, you don't get fines for that. In most circumstances, if a Form 9 is not completed for an employee, or the document was not recorded in Section 2, again, you can give them a reasonable time to come in and get that done. Not a long time, but a reasonable time, as long as it sounds logical to you. So if someone says, "Oh, I don't have my documents," or in the deposit box, or with my parents in their state, okay, to get out there in New Mexico, pick it up, and come back to Colorado. That's fine. Let's see, what else can I tell you that might be helpful here? Oh, here's a good one. On PowerPoint 60 is about E-Verify. What if you forgot to run? You did an audit and you didn't run an E-Verify, and you are required to do that because you're either a government contractor or you've chosen to sign up for E-Verify or it requires E-Verify. So if the employee of the company was actively using E-Verify at the time, you can immediately verify case. But if you were enrolled in it but not actively using it, you should not create an E-Verify case. So it depends on how to do it. Again, a lot of times their process about that, they do prefer that employers correct existing I-9s rather than completing a new form if you can avoid that. That's helpful, but new to the old, and don't backdate the old. So remember, if you do a new I-9 form, don't backdate it. You put today's date of when you redid it. The date of hire is going to be whatever it is back in time, whatever that original is, but not backdate the form, okay? ICE for a minute, because we'll be wrapping up here shortly, but ICE, primarily enforced by ICE. They're going to send a notice, 72 hours, as I mentioned that. Then you will get possible notice of technical or procedural failures. This is the first one I teach companies. We're going to get that, and we have 10 days to turn them around, and we want to do that. It saves us money. It means the government's saying, look, you've got a bunch of them that are messed up. We're going to give you 10 days to fix them. If you fix them, we're not going to target you. So that's how that works. The most feared item we get from ICE is this notice of suspect document, NSD list. We hate getting those. It's the list of all the people who ICE has identified as using counterfeit documents or not matching documents they gave you don't match, and you have to take action right away, within 10 days or less to let them go. You give them a chance to challenge though and correct it. We always have a protocol and script that we give people to use, and we do have some challenge. It's so heartwarming to save some of those notes, but a lot of times they can't, and they have to be let go, and that's it. And they can't. So they have to be cleared from then on. Anyone on an NSC list, I always have people create a secondary hire list, and it's kind of a secondary list because people can be rehired, but it reminds you have to check those people separately, and oftentimes we send a letter to ICE cleared in writing every time to be safe. Because some people do get legal status at some point, or they get under DACA, or there's something that happens, or someone sponsors them, or something. So it can happen. Notice the discrepancies requires a little bit of follow-up, and it can oftentimes mean the person gets this to working. We have to go through a little stuff. They have to sign it. They have to follow up. Warning notices. There are errors that ICE isn't going to find. Those are so hard to get. We get a lot of warning notices. We're so happy when ICE does that. Very happy. It's a very proud day. It also, though, puts you on notice of any future mistakes, so they'll come back at you harder. But it is a nice thing that happens, and they do happen today. Notice of intent to fine is going to be your fine. We always are sad to get those too. All the work you lose employees under NSP. You're trying to rebuild your company. Your items now be complete and accurate. Turn around and you still get fines to deal with on top of it. So there's a process. We can test them. We try to work with them, try to get them resolved where we can. How much are we talking? As I mentioned, substantive violations, like if you forget to sign as the HR professional or manager, and you forget to sign in Section 2, that can be $1,000 or $1,100 a piece. That means you also open the door to knowingly, because that's the document that should have been signed. That becomes a problem. They have a fine schedule. They have mitigation. But, you'll find if you can make the case for certain items, they sometimes will help you get it resolved. Depends on the good faith of the company, what they've been doing, how organized they've been to deal with ICE. So there's a lot of things that matter that save ICE time. So they do get credit in some way for that, and in the way they view your company. You go into a little better category when you're on top of it. The other fines you can get, first offense really can be for knowingly hiring people, $375 to $3,200 a worker. So remember how I said if you miss the deadline of expired documents, there you go. There's our problem, right? It can happen. The second can be $3,200 to $6,500 per worker. Third can be 4,300 to 60,000, and then you can have criminal, which involves jail time and seizures. So for assets. So we don't want to have any of those. The penalties for harboring, if you're knowingly hiring 10 or more in a 12-month period, that can be a bad thing. Penalties can include asset forfeiture and prison time. Golden State Fence is a good example to use. They were out there. They did their I-9 audit. They had ICE audit them. They got through the system, and then what happened to them is somebody snuck back on the payroll under a different name. That's what you have to be concerned about. You let everybody go, you get through this drama, and then people sneak back on the payroll because they like working at the company. They want to keep what they know, and they're using a different name and number. So that becomes an issue. They had to forfeit $4.7 million, and the owner received 6 months of house arrest because he didn't have direct knowledge, but the protocols weren't in place to keep them from coming back on. So that's why we take that so seriously on how you keep track of this NC list. It's a very important one. Let's see. There's a good faith defense. We try to use that at times, notwithstanding a mistake that's made, it's inadvertent. You can correct those technical or procedural. I mentioned that within 10 days, and they will give you that opportunity. However, ICE has what's called a virtue memo, and during a second audit, they don't like to give the good faith defense for the same type of technical or procedural defects that were subject to the first. So be forewarned about that, especially if you had a warning notice in the first one. If you did have a warning notice, they might allow you a good faith defense, but they usually don't like to if you paid a fine on the first one. On a second or subsequent audit, ICE may not allow the employer to correct the technical. So we've had that situation arise and have tried to work through ICE on that. If you use an electronic I-9 system, what do you need to pay attention to? Well, the security of the system, the usability of the system, the audit trail, the cost efficiency, the ability to track usage. It's very important. ICE wants to make sure it's a trustworthy, transparent system. They don't agree that all those out there for sale by these big national companies that are doing that or that are offering to you are valid. So keep that in mind. Electronic I-9 system must be able to produce the electronically stored I-9s and supporting documents, their associated audit trails, reports, and other data used to maintain the integrity and reliability of this record. Electronic signatures can be used, but only if you're following electronic signature rules. So it has to be secure, and it must comply with the Electronic Signatures Act. Again, make sure that it's backup, only authorized people are trained on it, those kind of things. So that gives you some ideas on these pages, and 71 also has an audit trail of what ICE likes to see for an electronic I-9. Name of the employee, type of event, are they updating, adding it, revising it, date and time stamp, where they click the buttons, what field was altered, what's the old data, what's the new. So it's really, truly an audit system. So keep in mind, you have to have that. We already talked about the Anti-Discrimination Act, so I'm going to go through that kind of quick. But again, you cannot discriminate on national origin discrimination. OSC, the Office of Special Counsel under Department of Justice, says don't retaliate. Look at the facts, not the faces. That employers must accept documents that reasonably appear genuine, and it prohibits asking for more or different documents than the employee presents. So that's where that comes from. It's very important. It's enforced by DOJ. People have 180 days to make a complaint. They'll investigate it. And then people can actually pursue it on their own if they want to. But we have had complaints over this. We do get E-Verify audits. We do get discrimination audits over how the I-9 process is handled. A couple of quick cases for you. This just came out May 27th, 2015, so very, very timely. The largest anti-discrimination settlement in DOJ history, a year ago, I should say. $320,000 compensates workers who lost wages due to the unlawful hiring practices. They required training for HR professionals, reporting and monitoring for 3 years. They had to revise hiring practices. And what they were doing was they required non-citizens to provide documents issued by DHS, the Department of Homeland Security. They wanted to see their permanent resident cards. You can't do that. You have to let them choose what documents to print or to present. Farmland Foods was a big one, $290,000. Again, required training for HR. They had to do monitoring. They had multiple I-9 and E-Verify violations. They also were requesting more documents than required to complete the I-9. They requested certain employees to provide green cards to prove they were authorized to work. They rejected documents that reasonably appeared genuine. things like that. They target people who look foreign, all the things, and they fail to follow the E-Verify tentative non-confirmation procedures. So remember, E-Verify has some procedures that if you are uh, if you receive a tentative non-confirmation, you must allow the employee to present documents, to challenge it, things like that. And so you have to print those, provide those to the I-9. So keep that in mind for E-Verify. Now also, UCSC, they got a penalty of $115,000. They were requiring documents from non-citizens that were not required from citizens. So you see the pattern. And the reason we put some of those in there is because people are making this mistake today, even now. And I even had a company this week was trying to buy another company, and they keep targeting the non-U.S. citizens. They can't even talk like that. I keep trying to explain that to the law firm. So it's important. The company, this one is in Colorado. This is an interesting one. I put it in here. It's from California. Of course, California is its own world, right? But it did go to the Ninth Circuit. Above that, the Court of Appeals. The company terminated this guy's employment when his e-visa was no longer valid. Now, you would normally expires, right? I told you they can't work again. So they hired another person who actually had a visa. This guy that they fired was also probably eligible, but he didn't have it in time. He stood and said, hey, you can't fire me. That's a breach of contract. That's national law discrimination. And national law discrimination is a California law. He ended up getting $1 million because he was let go when he wasn't authorized to work. The Ninth Circuit said the company should have given him more leave time while he was resolving his visa issue. So there you go. No good deed goes unpunished. Here's a little thing with the National Labor Relations Act. Fresh Farm was a produce packaging company in Arizona. It was required by a new owner, treated all employees and new hires, and did I-9 and E-Verify after they talked to DHS, Department of Homeland Security. Some employees were separated after an E-Verify final non-confirmation. Various employees were trying to unionize. They filed NLRB charges, or unfair labor practice charges, alleging that the separations were based on unionizing activities rather than E-Verify non-confirmation. An administrative law judge at the NLRB found the separation of employment was due to protected activity and ordered unconditional reinstatement regardless of E-Verify. That's a little crazy. Fresh Farm agreed to rehire if they passed E-Verify. NLRB sought a court order requiring them to reinstate the workers. The court said that NLRB could not require employers to forego lawful, non-discriminatory use of E-Verify, particularly in Arizona where E-Verify is mandatory. In other states, use of E-Verify may be mandatory subject to bargaining for union employers. So you got to watch your collective bargaining agreements also. All right, quick wrap up. We're almost to the end. And a couple quick things I wanted to wrap up with. Tips regarding ICE investigations, 72-hour notice, again, 3-day rule. Keep copies of your I-9 forms. ICE will receive and provide the notices we discussed. The biggest problem you have when ICE starts is the crisis communication plan. How do you communicate to your bank? They will be concerned. I will tell you right now, I've had to do many communications with banks about covenants. Are they going to make it? What's going to happen to the company if they lose people in the NSDs or the notice of suspect documents? So have a communication plan to your vendors if needed through the public raid or something. But if it's quiet, your banks will need to know. Sometimes your auditors will need to know. You have to make plans to transition and train people so that you have people to do the work. And you want to, correct your I-9s and follow best practices. Sometimes we get things fixed for that. The fines, the trends in criminal enforcement in real life cases is huge. This was an Orchard case in June 2015, $2.25 million. The 2012 audit found over 1,700 unauthorized workers. ICE came back, and we are seeing that all the time. ICE comes back and does 2 audits. 2014, the audit found that over 950 of those unauthorized were still employed. They could have been pursued criminally. Anyone can when this starts happening, but they didn't pursue it there. Advanced containment system, $2 million in forfeiture of assets and immigration compliance measures in exchange for agreement not to criminally prosecute. So they made a deal. They gave up big money, big assets to not be criminally prosecuted. 44% were undocumented. Many employed with numerous egregiously suspect identification documents, misspelling of agency names, and containing the words novelty items like from a local carnival place, right? So remember how I said the most important thing is your fully complete I-9 is properly done. Danny's Car Wash. In April 2011, the ICE audit found over 900 unauthorized workers. Companies separated their employment, but owner later ordered that many be rehired under different names. That would be a huge no-no, right? The company knew unauthorized workers used stolen identity to pass and verify. Managers were prosecuted. Owners and 13 managers pleaded guilty to charges including conspiracy, immigration fraud, and identity theft. Owners sentenced to 1 year in prison and 1 year house arrest. Other managers received probation. Companies forfeited $156,000. Sun Drywall and Stucco, 27 undocumented workers with no I-9 completed at all. Company pleaded guilty to knowingly employing them. They had begun correcting practices, agreed to pay $225,000 in restitution and $225,000 in forfeiture. The office manager sentenced to 2 months prison, 1 year house arrest, and 3 years supervised release. So these things are real. I won't keep going through the rest of them. They're there in there. But keep in mind, we do talk about the Tyson food case, the road employment defense. We do like it that the company has protocols. That's really the message of today. The company has protocols and procedures. They make sure that people are following it. And if you have some road manager who's off, violating rules and counterfeiting documents, we can argue that we had no idea. The lower level manager broke the rule and it shouldn't be held against the company. So that's what we call the road employee defense. I threw in the black and blue restaurant case. It talks about how Okaho, who handles the hearings for these, is where we appear before when we actually appeal and contest a set of fines that comes in. And they do give some credit for smaller businesses, limited financial resources, that kind of thing. Now, to wrap up here, a couple minutes. E-Verify tips, again, just double check, make sure if you're using E-Verify. It is a choice in many states today, but it will be the trend. I will tell you right now, anyone in the country, once we get immigration reform, it will be a requirement of Congress that everyone use some form of E-Verify. You want to make sure you check your dashboard regularly, don't miss anything. You do have to register online, and it is electronic. You have to go through a little test and that kind of thing and have limited people who are involved in doing your E-Verify. I threw all this in here because I know some of you it's new to you and you know it's maybe coming and you're trying to learn it. There is some do's and don'ts that we publish. The book from HR Simple and the Chamber has great materials on I-9, E-Verify, and immigration compliance. So if you want that, go online and get that. It'll help you understand if you're a federal contractor how to use it. You can even use E-Verify site by site or company wide in certain states. The one thing to remember is you have to do your I-9 first. You can't do E-Verify and then just jump to E-Verify. People have to pass the I-9 process first. If they don't pass I-9, you don't get to be E-Verify. Keep that in mind as well. When you receive a further action notice required on PowerPoint 95 here, you must have the employee sign it and you keep it with the I-9. They get a copy, you keep a copy. If they contest it, the same thing. You must print it and you have to keep it. So don't forget that. Super important. They do come and check that. It happens regularly, and if people challenge it, there's about 10 business days to resolve it. You need to go back and check the dashboard. If it says it's a non-confirmation, you have to not let them work another day. If it says employment authorized, they get to keep working. And keep in mind, you can't take adverse action against an employee while they challenge the tentative non-confirmation. They get to keep working. You do have to complete your E-Verify within 3 days. Don't require individuals to use self-check. You cannot do E-Verify pre-hire. Again, they all have to be hired, all right? So don't use them for applicants. That's just what a few of these PowerPoints are letting you know. And again, don't terminate employees because they challenge it. That's against the law too. You have to let the employee work. And we talked about the listing document for E-Verify. If you have signed up for it, they do get to use a photocopy. Make sure to close all your cases correctly. And I also put on PowerPoint 102 some of the details with the updated manuals that E-Verify prints. 103 is your wrap-up on everything. I-9 and E-Verify. It's right in the book also that HR Simple distributes. And it tells you how to deal with an employee from day 1 to day 3, probably one of the best tools I can give you today. So having said that, we'll wrap up today. We want to thank you all for your attention. I hope you've learned a lot. And let me turn it over to Eric to talk a little bit more if he wants to wrap up on behalf of HR Simple. Thank you so much for your attention. This is Julie Pace from Cavanagh Law Firm. I'll turn it over to Eric.
All right. Thank you, Julie. If you can just go ahead and flip over to the SHRM and HRCI codes in case anybody needs those. Yeah, I think we just set a Guinness World Record for most I-9 information in an hour and a half. So I just want to thank Julie for being awesome and thank everybody for listening. We're also, if you flip over to the next slide, Julie, there's the book that Julie mentioned a couple times. It's got a bunch of good tools in it. Julie writes it, and I would say the book is the apple doesn't fall far from the tree. That probably doesn't apply, but the book is just as good as this presentation. So use that code and save 50% on it. You can get it at hrsimple.com/federal. Julie, can you flip over to the next slide? And yeah, there's Julie's info. You had a ton of questions. We didn't get to any of them today, but I have a list of all of them. And
we'll try to go through them.
It's because the presentation is that good. We didn't have time for them, but I'll make sure I get all of those to Julie, and within the next week or so, we'll try to get back to each of you and help you out.
You bet. And we can follow up. Thanks again.
Yeah, thank you. We'll go ahead and end it here. But thanks all for sticking with us, and thanks Julie for hrsimple.com and the Cavanagh Law Firm. We hope you see you again. Thanks for coming out.